Kalpesh sir, can we start the session?
Yes, please start here. Dr. Umar, shall we start? Yeah.
Good evening, everyone. Welcome to day 4 of the 10-day online capacity building program on ADR, legal aid and allied laws, jointly organized by JSS Law College, Mysuru and Pro Bono India. We are truly delighted to welcome back Mr. Kalpesh Kumar Gupta, the founder of Pro Bono India, and the distinguished speaker of the day, Dr. Mohd Umar, who already addressed on day 2 of this program. His session was highly engaging and insightful, and we are fortunate to have him join us once again today. Dr. Umar is an accredited civil and commercial mediator by the Singapore International Mediation Institute and currently serves as a consultant and trainer at Samvad Mediation Center, Lucknow. He is also recognized as a mediator by the International Mediation Institute, Netherlands, which is the world's leading body for mediation standards. Sir is a dedicated academic. He holds a PhD from the Center for International Legal Studies at Jawaharlal Nehru University, New Delhi, and has contributed significantly to the dispute resolution in both national and international contexts. Today, he will be speaking on drafting related to arbitration and mediation, a topic that is crucial for all of us looking to deepen our practical understanding of ADR mechanisms. On behalf of the organizers and all the participants present here, I welcome you, sir. Thank you for joining us today, and it's an honor to have you with us again.
All right, wonderful. Good evening to the organizers and good evening to the participants for having me again over here. And I got good reviews of the previous session. I hope I'm able to match your expectations in this session also. But to just give you a marker, the session is, it would be conducted more in a workshop mode than a lecture mode, because in mediation, I just wanted to tell you about mediation, that how exciting the practice is. But we also teach arbitration and mediation in our courses. So this time I'm excited to tell you about how drafting works in arbitration and mediation agreements. So perhaps that is something which takes a good amount of time, at least let's say if we conduct it in a full-fledged workshop way, it would take at least half a day to really tutor you in drafting arbitration or mediation agreements. But since we have limited time, let me try to give you it in a form of a capsule so that you are immediately able to absorb it. So first of all, please confirm if you are able to hear me, all of you.
Yes, sir.
Am I audible? Okay, wonderful. So if you are able to hear me, the first thing that we should understand in the case of drafting of mediation agreement or arbitration agreement is that it is as crucial as any important legal document should be, right? So number one, it is in the nature of a contract, all right? So it is in the nature of a contract. It is having the force of a contract. So mediation agreement, arbitration agreement. So any agreement that is enforceable in a court of law is called a contract. So one thing is for sure, that mediation agreement and arbitration agreement are having the nature of a contract. So this is one thing. The second thing is that before we deep dive into the drafting of these two agreements, let us try to understand the meaning of arbitration agreement or the meaning of mediation agreement. Is it a simple sentence? Is it a paragraph with certain important elements? Is it a separate agreement in itself? Is it done through postal exchange? Is it done through the email exchange? Or is it, is it just claimed, and if not denied, then it also is covered as an agreement? So let us try to explore these areas first, have a sense of what agreement is in the first place, and then perhaps we will go into the drafting of these agreements with certain model clauses that I would put before you. All right, so let me see if I can share the screen with you. Please let me know if you can see the screen.
Yes, sir. It's visible.
Okay, wonderful. So, see, the first thing that I told you that these agreements are in the nature of a contract, all right? The second thing that I have told you that it should be very, very meticulously drafted because there are certain very important elements which, if drafted wrongly, can spell doom for the parties, right? Number three, we need to understand the meaning of the arbitration or mediation agreements, right? So this is what we are going to do right now. And then we will, of course, advance to the drafting of these agreements. Let me open up the act before you. Well, to put it here itself, in arbitration, the arbitration agreement is defined under section 7 of the, give me the law which governs arbitration. I'm sure you had a session on that. Which law governs arbitration? Anyone?
So the Arbitration and Conciliation Act of 1996.
Yes. Arbitration and Conciliation Act of 1996. So section 7 of ACA talks about arbitration agreement. And in mediation, section 4 of the Mediation Act 2023 talks about the mediation agreement, right? Now, what is an arbitration agreement and what is a mediation agreement? All of you have a broad idea about what arbitration is and what mediation is. So I'm presuming that because you had sessions on each one of them. Now, let us say that if there are two parties, party 1 and party 2, these two parties want to settle their disputes through ADR mechanisms, right? And they decide to have an agreement with regards to incorporating any of the ADR mechanisms. So this agreement can be for the future disputes, or this can be also for the present disputes. So it can be an ongoing issue between the parties. They can agree that, okay, let's take it for arbitration, let's take it for mediation. So this is one thing. The second thing is the parties entering into a contract can decide that if the dispute would arise, then we will take the matter for any of the ADR mechanisms that they may decide, right? So if this much of things are clear to you, let me take you straight to the provision. Let us first start with what do we mean by arbitration agreement under section 7 of the Arbitration and Conciliation Act, right? So, all right, let me know if you're able to see the act on the screen.
Yes, sir. We're able to see.
Okay, so this act is from 1996. It is not an updated copy of the act because after 2019 several changes have happened, but nevertheless section 7 remains the same, so that is for our purpose, right? Okay, please let me know if you're able to see section 7 on your screen.
Yes, sir. It's visible.
Okay, so the first thing is that the arbitration agreement is an agreement where parties submit to arbitration all or certain disputes. So there can be several aspects to a contract. So the parties can make a general arbitration clause for all disputes which may arise out of a contract, or they can specify, right? They can specify that this is the particular dispute that we are going to take for arbitration in case if the dispute arises, right? So like I told you that it can cover present dispute or it can cover future dispute. So that's what the clause 1 says. which have arisen or which may arise between them, right? So these are the elements that you need to know first. Now, clause 2 tells you that what an arbitration agreement may look like, right? So look at this. It is saying that an arbitration agreement can be in the form of an arbitration clause in a contract or in the form of a separate agreement, right? So if I explain it to you on the blackboard, then perhaps you would be able to understand. So if you're able to see the blackboard, I'm drawing something for you, okay? So let us say that this is the contract, okay? Contract C. So we have title of the parties, title of the contract, etc., details of the contract, clauses starting, all of that happening. It's a regular contract, right? Then one of the clauses say that if the matter arises between the parties, they will go for arbitration broadly. I mean, there are many elements to an arbitration clause, which I will tell you, of course, in due course. But there is one clause talking about dispute resolution through arbitration. All right. So what section 7 is saying, that this clause itself in its independent capacity having the status of an agreement. All right. This clause itself in its independent capacity has the status of, please tell someone. I'm sorry, I'm teacher, I have to teach you like this.
Of an independent agreement.
Of an independent agreement, yes. So this is one thing about contract, right? As far as arbitration agreement is concerned. Section 7 says that you can have the principal contract, all right, with everything, every aspect laid down, and you can have a separate arbitration agreement, which lays down all the details with regards to arbitration, which has to be conducted if the dispute would arise between the parties. So there is no arbitration clause in the main contract. There is no arbitration in the main contract, but the parties choose to have a separate arbitration agreement. So this is also as good an arbitration agreement as a separate clause is in this case. Both of these aspects are covered as arbitration agreements under section 7. Is this much clear to all of us? Can I have an affirmative?
Yes, sir.
Okay, wonderful. So this is one thing that you have understood about agreement. Now, it is important, section 7 says, that the agreement is in writing. See, usually what happens is in the Indian Contract Act, the verbal contracts are accepted as valid contracts, right? But arbitration agreement, even though it is in the nature of a contract, it is supposed to be necessarily in writing. It can't be an oral contract. It can't be an oral agreement. So it has to be in writing. And what do we mean by arbitration agreement being in writing? So the first thing under clause 4, if you will see, the first thing is that the document is signed by the parties. If the document is signed by the parties, it would be deemed as if this arbitration agreement is in writing. It should exist in the form of exchange of letters or telex or emails. Basically, you don't have to go into too much of detail into it. Basically, there should be some documentation. It can be a virtual documentation. It can be a hard copy documentation, right? It should provide a record of the agreement. There should be some fixation of that agreement. Some record should exist. So number 1, the agreement is in writing if it is signed. Number 2, the agreement should be recorded, right? In some tangible form, either physically or virtually. The third thing is, it would be considered in writing if an exchange of statement of claim and defense is alleged by one party. So one party says that there is an arbitration agreement between us, and therefore on the basis of that, I am bringing a case to arbitration. So this is an assertion by one party. And this assertion is not denied by the other party. So I'm saying that I had an agreement with you, we had it in writing, and everything else was decided. And you do not deny this assertion from my side. So this also would be deemed as if that yes, agreement in writing exists. Right? The last thing is, which is covered under clause 5, is a reference in a contract to a document containing an arbitration clause. Right? So let us say that there is a contract, right? And then this contract is having an arbitration clause very clearly written, right? Then there is another contract between the parties, right? Contract 2, this is contract 1. Now this contract 2 simply refers to this clause in clause 1. It simply refers to this clause in clause 1 that the dispute will be settled as decided in the previous contract. So it would also be considered an agreement in writing. So this is what we must know about arbitration agreement. So number 1, it can be for certain or all disputes, right? Number 2, it can be for present or future disputes, right? Number 3, it can be in a form of a clause. The agreement can be in a form of a clause or a separate agreement, right? Then number 4, it should be in writing. Writing means it should be signed by the parties. It should be having some exchange through letters or email or whatever for the purpose of record. There should be some record keeping of this. Third thing is that there can be a claim by one party and no denial by other. This way also it would be considered in writing. And also the fourth part, there can be a reference in another contract to the dispute resolution clause in the previous contract which relates to arbitration, and that would be also considered as an arbitration clause. Are these 4 points clear to you with regards to arbitration agreement? Please let me know.
Yes, sir.
Okay. If these 4 points are clear to you, the next thing that I want to share with you is the types of arbitration or mediation. See, the format that you see under section 7 of the Arbitration and Conciliation Act, a very, very similar definition is there for the mediation agreement under section 4 of the Mediation Act. So I'm not discussing it separately because we have a paucity of time. Very minor changes here and there, but majorly substantially remaining the same. So section 7 and section 4 are having the same effect and import as far as the nature of mediation agreement or arbitration agreement are concerned. All right. So now the next thing that we need to understand before we go into the drafting part of it or we look at the model clauses is that you should know about two major types of arbitration or mediations that happen. So one is ad hoc arbitration or mediation. The other is institutional arbitration or mediation. So ad hoc mediation is that there are two parties, party one and party two. They have a dispute. They choose Mr. X as their arbitrator or mediator. And Mr. X gives the desired outcome, right? So parties are choosing Mr. X, parties are choosing the place where the arbitration or mediation will take place. Parties are driving everything. Parties are drivers, all right? They are controlling every aspect of arbitration or mediation. In institutional mediation, parties submit their dispute to a institution where you have experts in arbitration or mediation who can do the job appropriately. All these institutions, they have their rules according to which the procedures are conducted. So both of these methods of arbitration or mediation, they have their own advantages and disadvantages. I will not go into that right now because it is not required and it is also not the topic that I'm supposed to cover. But the thing is that these are the two forms that exist. So one is you select your own experts who may resolve your disputes as parties. The other is you submit your dispute to an institution which has good arbitrators or good mediators associated with them, and then they take it forward according to the institutional rules. So once you have understood what does it mean by arbitration agreement or a mediation agreement, once you have understood ad hoc mediation or arbitration or institutional mediation or arbitration, now you are in a good position to appreciate the arbitration clause or an arbitration agreement or a mediation clause or a mediation agreement, right? Because in any of the mediation or arbitration agreement, you need to have a certain specific reference, whether you are going for an ad hoc dispute resolution or institutional dispute resolution. That needs to be very clearly spelled out. Otherwise, it creates a confusion. There is no, if important elements are missing in any agreement, there would be a lack of consensus ad idem. Parties may think that, we did not agree on this thing in the same sense. I'm sure you have read about this doctrine in your contract classes, right? So now let me share the model clauses with you. Let me show you how these agreements look like, how mediation agreement looks like, how arbitration agreement looks like. Before I go there, I need to ask you one question. The question is that is an arbitration clause in a contract, is that supposed to be an arbitration agreement also under Section 7 of the Arbitration Conciliation Act? Can that be an arbitration agreement, a simple clause in an agreement? Can anyone tell me?
Yes, sir. There are answers in the chat box as well.
Okay. I'm sorry, I'm not, I'm beyond that stage of being very tech friendly, but yes, thank you for the support. All right, very good. So you know now that whether it's a clause or it's a separate agreement, it can be considered as an arbitration agreement or a mediation agreement under Section 7 of the ACA and Section 4 of the Mediation Act. Okay, now let me take you forward by showing you some model clauses. Please let me know if you are able to see the model clauses file on the screen.
Yes, sir.
Okay. look at this. These are the clauses which are inserted in a particular contract. So one of the contracts which is quite famous and fashionable these days is also the catch-all dispute resolution clause. Now, this dispute resolution clause does not, stick to any one form of dispute resolution. In fact, it covers all sorts of available options before the parties choose to go for courts, right? So these are popularly known as catch-all dispute resolution clauses. So if you will see over here, what it is saying that the parties, if any dispute arises, the parties will resolve those issues through negotiations. So the first stage is negotiations between the parties themselves. Now, negotiations are not governed by any law except for the Contract Act to some extent, right? So negotiations are happening between the parties. But as you already know, that mediation and arbitration requires the involvement of a third party, right? So usually it so happens, and it has become a very commonplace clause now, that the first stage of dispute resolution is that the parties must try to negotiate between each other, right? Then this clause says that if the matter is not resolved by negotiation, let's say within 30 days, the parties will attempt to resolve the dispute in good faith through mediation. So now the gears have shifted. For 30 days, negotiations have not worked. But what can work according to their assessment? They think that going to the mediation can be a good option if negotiations have failed, right? Let us say that if mediation also doesn't yield any results, then within 60 days of the initiation, the dispute can be referred to arbitration by any party. So this is a great thing, people. I don't know if you understand this or not, because initially the first response of the of the parties was always litigation. That okay, so you are trying to play smart with me. Let me take you to the court and get justice over there. But then justice never arrived, and justice delayed is justice denied, as we know. So now the parties, after Arbitration Conciliation Act and Mediation Act and all those things that we have, the parties are at the liberty to have these kind of catch-all dispute resolution clauses where they are creating hierarchy for themselves. That first we will negotiate. If that doesn't work out, we will mediate with the help of a neutral, and then we will go for arbitration if mediation also fails. So this is a general thing that you should look in this clause. After that, these are some aspects where you're seeing the blanks. These are some aspects which you need to look at very, very carefully, right? So now the parties are writing down the details of how they would conduct these dispute resolution processes. The first thing they say is that the place of mediation and seat of the arbitration shall be, let's say, India, okay? Now, you may ask me, sir, place of mediation is understandable, that mediation will take place over here. What do we mean by seat of the arbitration, right? So in this, you must understand. Anyone who knows the difference between the seat and the venue of arbitration? Anyone who can tell about that? I think you had a class on arbitration also. Just in case if it hasn't been covered, I will cover it because it is important for you to understand at this stage.
Yes, participant, please respond. Yesterday, Akash
So-
discussed
Sir,
seat
does
and venue.
seat
So, the venue of arbitration is restricted to initiating arbitration proceedings, sir, and the seat of arbitration is with respect to the enforcement or challenge of the arbitration award.
Okay. So to partially correct, and there are some errors also, but let me try to articulate it for you. So venue of arbitration is simply a geographical convenience of the parties. wherever they want to sit for arbitration. They like the weather of Singapore and they also want to take their families along, or they want to go to London for arbitration, all of that. So they can choose any venue that they want. Seat of the arbitration determines the jurisdiction. It determines the jurisdictional grounding of the arbitration. If at all it would be enforced, in which jurisdiction it will be enforced. If at all it would be, contested, in which jurisdiction it would be contested. So the venue is just a geographical convenience, and the seat of arbitration gives you the jurisdictional grounding. So it is important for the parties to lay down the seat of the arbitration, because if you don't have the seat of the arbitration, where will you get it enforced? Where will you get the award enforced? Right? In which jurisdiction? So you lay down the place and of the mediation and seat of arbitration. It is also important, especially in a multi-party dispute or even in a bilateral dispute, where there are two companies from a different lingual background, right? So the language has to be very specifically laid down. And if they both share the common language, then you put it over here in the blank. If they don't have the common language, then there should be some additional clause saying that the translated copies would be provided to the other party and to the parties, and the language of the mediation or arbitration shall be this. Now, the other thing that is important for you to understand is the contract, basically the contract to which this clause is a part. This contract will be governed by the laws of which country? If it's an international arbitration or international mediation, you need to lay down specifically the name of the country, the laws of which it would be applied. If it is Indian company only, if it is Indian parties, both of them, then you don't need to have this kind of a clause, because then of course, the presumption is that the Indian laws would be applicable. The arbitration shall be governed by, again, these are the two companies from different jurisdictions. So they need to zero down on a particular substantive law for arbitration that they would be using. So let's say if they choose Arbitration and Conciliation Act of India, so they would write down the name of that law that would govern their arbitration. So this law is governing their contract. This law is governing their arbitration. This seat of the arbitration is determining their jurisdiction. So there are lots of technical things that you need to incorporate in any clause, right? You can also lay down, if it is required in your case, let's say you have a hyper specialty case. It's a construction case where you need a real estate expert. You need an expert engineer to really take it forward and all of those things. So if you think that your arbitration is a hyper specialty arbitration where you need necessarily an expert arbitrator in a particular field, then you also lay down the qualifications. All right. Then you also lay down the qualifications. And this is, of course, subject to your requirement, whatever you may require. Right. And this is a clause which, again, gives the parties their rights to go to the courts are retained through this clause. It says that nothing in this clause shall be construed as prohibiting a party or its affiliate from applying to a court for interim injunctive relief. So the doors to the court should always be open. No contract, including the arbitration agreement or mediation agreement, can scuttle or prohibit the parties from going to the court for any injunctive relief that they rightfully legally deserve. Right? So it can also be spelled out very, very clearly in a dispute resolution clause. So this is a clause that gives you a glimpse of how catch-all dispute resolution clause looks like in any contract. Is this understandable to all of you, the catch-all dispute resolution clause? Did you understand the elements of it? What are the necessary elements and why they are important? Why is it important to lay down the seat? Why is it important to lay down the language or the governing law for contract, governing law for arbitration, qualifications? All of this is making sense to you?
Yes, sir. Yes, sir. It is.
Okay, okay, wonderful. So this is a catch-all dispute resolution clause. Now let me show you specifically an arbitration clause, right? So this clause is actually a clause for institutional arbitration where you submit the dispute to the institution. So if you are going for ad hoc arbitration, where the parties are choosing everything, the arbitrator and the place and venue and everything, then it will be accordingly modified, right? So if you're able to see, it says that any dispute arising in connection with this contract, the principal contract to which this clause is a part, including any question regarding its existence, etc., shall be referred and finally resolved by arbitration administered by the I've just named it randomly, right? So ABC Arbitration Center, in accordance with the rules laid down by the institution, right? For the time being in force, which rules are deemed to be incorporated by reference in this clause. So you are submitting your dispute to this particular institute, right? And in accordance with the rules that this institution adheres to. Apart from that, you also lay down certain details with regards to arbitration. So one thing you have to be very, very sure, the seat of the arbitration, right? You have to lay down the seat of the arbitration. You can also separately lay down the venue of arbitration, which can be anything. Otherwise, seat would be only considered as the venue, right? Then the tribunal shall be consisting of how many arbitrators? What would be the strength of the tribunal? See, let me take you to the Arbitration Act. I hope all of you are able to see section 10 of the Act on your screen. Please let me know.
Yes, sir.
Yes? Okay. So section 10, if you will see, it clearly says that the parties are free to determine the number of arbitrators, provided that the number shall not be an even number. So the arbitrators are always supposed to be an odd number tribunal. It is always supposed to be an odd number tribunal. Can anyone tell me why is that? It can either be one arbitrator or three arbitrators, five arbitrators.
Neutrality, sir.
Yes. Can you explain more on that?
Sir, if there are even number of arbitrators and if they have if they have opposing opinions, there will be a deadlock situation.
Yes. So there's no outcome. So parties are
Yes.
investing so much of money in arbitrator, paying him FT amount, going to the venue, London, Singapore, everything is happening. But then there is no outcome because one arbitrator is favoring one party, the other arbitrator is favoring the other party in its award. So that is why, to resolve this possible anomaly, the statutory requirement under section 10 of the Act is that the number of arbitrators will always be an odd number of arbitrators. So coming back to the clause, your arbitration clause should be mentioning that how many arbitrators your tribunal will consist. The language of the arbitration is important, and the contract under which the arbitration is governed. Of course, the arbitration agreement in the case of India, it is governed by the Indian Contract Act. If it's an international arbitration, then accordingly, the contract governing clause would be decided. But this is how an arbitration clause looks like. So before you draft it, you need to look at it, right? The third thing is the mediation clause. Now, mediation clause, because we do mediation ourselves, so we have, we have mentioned both the ad hoc mediation clause as well as institutional mediation clauses, right? So look at this. In ad hoc mediation clause, there is no reference to any institution. It is simply saying that the parties may at any time, without prejudice to any other proceedings, seek to settle any dispute arising out of or in connection with the present contract through mediation. A simple statement that if any dispute arises at any stage, we will go for mediation, right? Then you can, of course, lay down the details. For example, the place of the mediation. In mediation, we don't have the issue of seat and venue and all of that, right? It can simply be the place of the mediation. In fact, I think I told you in the class on mediation that mediation even transcends the territorial jurisdictional issues. Under Section 13, you can be sitting in Lucknow and mediating for the parties situated in Delhi or Kerala or whatever. The language needs to be very certain. One of the problems in the case of arbitration is that arbitration is almost 100% English language. And because it is totally commerce oriented, the benefits of arbitration never reached to the non-commercial participants who may have been included in that process. But in mediation, the good part is that from top to bottom, everyone is open to mediating. So when you are engaging with parties who are not comfortable in English language, they are able to express themselves in their vernacular language, then it is the duty of the mediator to conduct mediation in their language. If the mediator can't conduct the process in the party's language, then he or she should recuse, right? So the language is very important. The contract to which mediation is subject to, what is that contract, under what law that contract falls, you have to mention that. And the mediation is governed by which law? In our case, of course, it would be the Mediation Act. And if at all the parties want to have the mediator to have any necessary qualifications. Now, one very interesting thing over here, maybe if I will have access to you, I will share you a podcast that we did. And it is a common knowledge in the mediators also that in mediation, you don't need a hyper specialization in any field. Let's say if there is a commerce dispute or intellectual property dispute. So a mediator need not be a very well, versed with intellectual property law. Just a functional knowledge of what do we mean by IP, how does the rights and liabilities arise, all of that is sufficient. What matters in mediation is your ability to command the process. If you're able to command the process, it can be any field and you would be good to mediate. You just need a functional knowledge, a working knowledge of that particular field. And that can come by reading a couple of articles, right? Today we have such information explosion. So this is how mediation clause looks like. And then we have institutional mediation clause, which of course mentions the institution, right? So we have mentioned ABC mediation rules and all of that. The other elements remain as it is. So in the ad hoc mediation clause, we don't have a reference to any institution because parties are deciding everything. In institutional mediation, we mention the institution and the important elements with regards to language, strength of the panel, where it would be conducted, what would be the qualifications of the mediator. So this is how these clauses look like. Catch-all dispute resolution clause, the mediation clause, and arbitration clause. Now, the thing is that when you will search for a model clause on arbitration or mediation on internet, you will find at least 100 samples, differently phrased, differently framed, but perhaps having all the core elements very similar to what I have just shared with you. And for this reason, I want to share one case law with you The name of the case is Rukmani Bai versus Jabalpur Collector. Can you see on the screen Supreme Court case 1980?
Yes, sir.
Okay. In this case, the court very clearly stated, let me take you straight to that particular part of the, yes, this is the statement. If you're able to see it on the screen, it is very clearly saying that the arbitration agreement is not required to be in any particular form. So there is no internationally agreed upon or nationally agreed upon form to an arbitration agreement. And the same logic applies to mediation agreement also. So you will find different types of clauses being drafted over there. But I hope you have understood the core elements which need to feature in any dispute resolution clause. Those features are making it clear that we will go for dispute resolution, any of the ADR mechanisms you can mention. Number two, the language, the strength, the qualification, the place in case of arbitration, the venue, the governing law for contract, the governing law for arbitration or mediation. These are the important elements that you must incorporate in your clause. Is that clear, everyone? Please let me know.
Yes, sir, it's clear.
Okay, if it is clear to you, now what do we do? How do we utilize our next half an hour? I have created a certain sample contract for you because dispute resolution clause can only be learned, the drafting can only be learned by doing it yourself, right? So dispute resolution clause, I'm giving you one sample. This sample of contract is generated by the artificial intelligence. It's a one-page mini contract with a space for dispute resolution clause. So I need to share it with you. Should I share it in the chat box if that is okay? I think chat box has the option for attachment. I don't know if I can send it to you through attachment.
Yes, sir, we can attach a
Yes,
file.
attach here.
Okay. Which symbol to click? Yes, okay, file. Yes. So just give me a moment. Let me attach this file for you, and then let me take your responses. I have sent you the file titled as supply agreement. Please tell me in the chat box only if you have received it.
It's there, sir, we've received it.
You have received it. All right. Now you all can download it. Just hold. Okay, I got it. You have received it. No need to type now. Now you have this mini contract before you, just a sample contract, and there's a space for dispute resolution clause. Now your task is, in the next half an hour, you need to draft a dispute resolution clause. It can be any clause that I have told you. It can be a catch-all dispute resolution clause. It can be an arbitration clause. It can be a mediation clause. It can be an institutional arbitration or ad hoc arbitration. It can be an institutional mediation or ad hoc mediation. So I give you complete freedom to put up any dispute resolution clause related to this agreement and submit the same to the organizers. Or you can send it to me also with a CC. I will share my email ID. My email ID is mdumar2417@gmail.com. So when you send it to the organizers, Professor Kalpesh, I think you can also put down your ID if you want to have it.
Yes, I will share, yeah.
Yes. So this is one exercise that we need to do so that they learn how to draft the arbitration agreement or a mediation agreement, right? So would it be a good idea to give them around 15-20 minutes, and they can then email the documents to you and me and to the organizers in JSSLC? Would that work?
Yeah. Yes, yes, yeah. The participant can respond.
Yes.
Yeah.
Yes, I think participants are looking at the agreement right now, a lot of them, that what this agreement is about. So the exercise is that you need to draft any clause, this catch-all clause, arbitration clause, or mediation clause, and put it in that dispute resolution section of this document, and then send it across to me and the JSSLC and Professor Kalpesh. All right. So you have around 15-20 minutes for that. Please do it. And if at all any review or comment is required, I would be most happy to send across my comments to you.
The participants may also send it in the WhatsApp group that we have so that we can share it with sir.
Yes. It can happen in the WhatsApp group also. So we will wait for 20 minutes now. Let them come up with a response. Okay.
రే వాళ్ళ డాడీ ఏమన్నా ఉంటే మంచిగా ఉంటుందా?
Participants, you can also share your drafted clauses in the chat box. I'm getting some emails, but you can also share in the chat box. Maybe we can review one or two here itself, so that you can get a sense of it. Some very good attempts, I must say, those who are emailing. But if you have something in the chat box, perhaps that would also be great. All right. So let us see. We have one where the dispute resolution clause is shared by Rajeshwari, where she's saying that first it would be amicably attempted to resolve amicably by arbitration between the parties within a stipulated time. The dispute shall be resolved by arbitration in accordance with the Act, the number of the arbitrators. All right, all right. Good attempt, Rajeshwari. You have covered almost all important points, but maybe a little bit of findings in drafting, but that would come. Of course, I can understand you must have drafted in hurry. So given that, full marks for your attempt. Let us see what Ankita has said. Shall be governed according to the laws of India and any dispute. All right. So any arbitration or dispute resolution clause should not straight away start with declaring the laws that are governing this particular agreement. You know, the initial part of the dispute resolution clause is always that you will go for negotiation or mediation or arbitration if the dispute arises. And how will you go? Will you go it in an ad hoc mode, or will you be referring it to the institution? This is how your opening should be, right? So that is something that we need to understand. This is how your opening should be. And the rest of the things you have incorporated the language, number of arbitrators, the law, and is there anything missing? instead of using the word legal place, please use seat, because seat is a correct word to be used. All right. Seat is a correct word to be used in case of arbitration. And you can also mention qualifications if that is something that works for you. Right. So I hope, give me, give me some sense, because we are now winding up. My task of giving you a sense of arbitration agreement and a mediation agreement and giving you a sense of drafting it is done. Now give me a hands up if you think that all the elements of arbitration and mediation agreement are clear in your minds. Please let me know. Can I have some show of hands? Otherwise, we will try to reinvent something. Only one person has understood it. Where are the rest of us? All right, all right. So now we are getting some responses. So what I will do is I will share these model clauses with you. In fact, they are freely available on Google also, right? So at any point of time, if you want to have a look at the model clauses of different institutions, different organizations, you can simply type into Google sharing the model clause, and then perhaps you would be able to get it. And I will also share it from my end. All right, Kalpeshi, I think we can wind up if things are fine. If there are any questions, I would be.
Yeah, sure. So we'll wind up in maybe maximum 5 minutes. Participant, if any question query, you can put in the chat box. Now we won't be entertaining, maybe sorry for paucity of time. The arbitration clause, you can put your questions right now. So I can see one of the question in the chat box. So what are some of the common mistake that one should avoid while drafting an arbitration agreement?
The most common mistake is that you simply mention the place of arbitration. And this is also a problem with the law of arbitration in India. Right now, the Arbitration Act does not differentiate between venue of the arbitration or the seat of the arbitration. It simply mentions place of the arbitration, which creates a lot of confusion. So the new 2024 amendment bill that is now pending in the parliament, that makes an attempt in differing between seat and venue. So this should be very clearly spelled out in any arbitration agreement, that what would be the seat of the arbitration, what would be the venue of the arbitration. And language also, especially if it is an arbitration between non-English speaking entities, right? So language also is very important. And the third thing is that, let us say, sometimes parties simply say in their arbitration clause that if any dispute arises, we will go for arbitration. So any clause related exercise should be taken up only with the help of the experts who are good in drafting. So let us say you say that we will go for arbitration in your contract. Now the dispute arises. One party says that I meant to say that we will have our own arbitrator and we will proceed with the process. The other party says that I meant to say that we will go to the institution to submit our dispute. Now there was no consensus ad idem at the time of the signing the agreement. So it can create those kind of issues. So these are some common mistakes that we need to avoid in any arbitration or mediation agreement.
There is a question, sir. Can you please repeat the difference between, one second, seat and laws applicable?
Not seat and laws applicable. The difference needs to be between seat and venue. And I also understood what you mean by seat and laws applicable. So perhaps you mean to say that what would be the difference between seat and the governing law, right? So say in international arbitration, we need to have a very good clarity of what would be the governing law of arbitration in a particular dispute. So generally, whatever the seat is, the law of that seat becomes the governing law of arbitration. For example, let's say if the seat is London, right? So the Arbitration of Act would ipso facto become the governing law of arbitration in that particular seat. If the seat happens to be in India, then the governing law of arbitration would be the Arbitration and Conciliation Act. Right? So that's how seat and governing law interact with each other. And venue is of course different. It is the geographical convenience of the parties. Wherever they think that their arbitration can give them best results, they go over there.
So there's another
Yes.
question in the chat box.
Yes.
As when we draft clauses that combine mediation and arbitration, how do we make sure that the same person acting as both mediator and arbitrator doesn't create fairness issues? What precautions should we include in the clause to protect the integrity of the process?
All right. So see, arbitration is a different process. Mediation is a different process. So the same person cannot be arbitrating or mediating, right? So that's what I would say. Ideally, both are having a very different mindset. So to avoid any conflict of interest, it is important that the parties are engaging different arbitrators and different mediators. If it's a catch-all clause. So this is one thing. The second thing is that if we want to ensure that there's a dignity in the process, there are two things that we need to understand. First is the element of disclosure, that the arbitrator or the mediator must disclose, if at all he or she knows any of the parties beforehand, right? So that there is no conflict of interest. The second thing is it is a statutory requirement that all principles of natural justice would be followed during arbitration. The arbitrator or the mediator would be dealing with the parties at equal level. There won't be any discrimination of any sort. If there would be a violation of natural justice, then perhaps the award of the arbitrator would be susceptible to be challenged under Section 34.
Thank you, sir. Another question here is, the object of ADR is speedy disposal of disputes. The catch-all dispute resolution clause refers the dispute to multiple ADR mechanisms. Would this process of attempting to resolve the disputes through multiple mechanisms not defeat the very object of speedy disposal?
Yes, so you have to keep the timelines very short. So for example, 30 days you give to negotiation, 120 days or 60 days you give to mediation. And if it doesn't work out in these good 150 or 180 days, which happens to be how much? Maximum 6 months, then you go for arbitration. And the arbitration timeline is 1 year. You have to wind up the arbitration within 1 year, otherwise it gets terminated. So with all the catch-all clauses put in place, still it would take maximum 1.5 years, right? Or maybe a couple of months more for the administrative delays. It is a better deal than going to the courts, right? Because you are able to get an outcome in 1.5 years or 2 years. But the moment you go to the court, there's no end to the tunnel, right?
So if would you be willing to take any more questions, or do we?
Please, I'm here.
Uh,
Just make me free by 8:15 because I have some
No,
work.
I think we'll close now. Sorry.
No,
If we
we
can
can
end.
take 1 or 2 more questions because, or alternatively, I have already given you my email ID.
Yeah,
Please
yeah.
feel free to write down the question to me. I would be very, very happy to respond. I will respond certainly. Okay?
Sure, sure.
Don't worry.
So we can go for a vote of thanks. Over to boardroom.
all right. Over to Anaga for the vote of thanks.
Good evening, everyone. As we come to the end of today's enlightening session on drafting related to arbitration and mediation, it is my privilege to deliver the vote of thanks on behalf of JSS Law College, Mysuru and Pro Bono India. First and foremost, our heartfelt thanks to Dr. Mohd Umar, sir. Sir, it has been an absolute honor to have you with us once again, and we are truly grateful for the time and wisdom you have shared with us today. Your deep insights and practical approach and clear articulation of concepts have added immense value for our understanding. A sincere thank you to all the participants for your active presence and enthusiastic involvement throughout the session by also replying to all the questions and the drafting session that was allotted by the sir. So your curiosity and interaction kept the spirit of the program alive, and it is your commitment to learning that makes these sessions meaningful. We also extend our gratitude to the faculty coordinators and the organizing team from JSS Law College and Mr. Kalpesh Kumar Gupta sir from Pro Bono India, whose efforts behind the scenes have made this entire program very smooth and impactful. Thank you once again, and we look forward to seeing you all in the next session.
Thank you very much.
Thank you. Bye bye. Take care. See you, everyone. Goodbye.